Speaker Pro Tem Blake Carpenter. Welcome to committee.
Thank you, Mr. Chairman, Mr. Vice Chairman, Ranking Member, and Committee. Appreciate you all having me in front of you this morning. And I'm sure you guys are all at the edges of your seats on how I came up with this language. Well, I was at the gym in 2020, 2021, and it just hit me. So started working on it then, started doing some research, found out 4 other states had the strict scrutiny language within their constitutions. Now, if you guys want to hear the flowery language, it's all there in my testimony that's in front of you. I'm not going to read the majority of it. However, I am going to read just a little bit of it, though. So for the record, for folks who are listening online at home that might not have my testimony pulled up. So our forefathers, in their unparalleled wisdom, recognized the right to bear arms as a fundamental liberty, integral to the American ethos. This right was not a mere amendment to our Constitution, but a crucial element in the architecture of our liberties, a bulwark against oppression and a guardian of personal autonomy and security. As we sit here and deliberate on HCR 5020, let us recall that our task transcends mere policymaking. We are upholding a legacy, a sacred trust passed down from those who forged this nation on principles of freedom and self-determination. The founders, in their foresight, enshrined this right to bear arms within the fabric of our Constitution. This right was not an afterthought, but a pillar of our liberty, a safeguard against tyranny, and a cornerstone of our security as a free state. As we deliberate on the merits of HCR 5020, let us remember that we are not merely discussing a policy decision. We are reaffirming a legacy that has been entrusted to us by generations of patriots who believed in the sanctity of individual freedom and the right to self-defense. Our nation's history is steeped in this steadfast belief in our right to bear arms. This right, enshrined in our Second Amendment, was not born out of a whim, but from a hard-learned lesson of history. Our founding fathers have endured the yoke of tyranny, understood the critical need for a populace that could defend itself not only from external threats, but from the overreach of its own government. They recognized this right was integral to the balance of power, a necessary means to ensure that our government remains of the people, by the people, and for the people. Before I open up to questions, I want to answer several of the questions, or at least make a comment, because I'm sure they're going to come my way too. I'll preface this by saying I'm not an attorney. The strict scrutiny I did do research, though, so I at least pulled that. But the strict scrutiny is the highest standard of review used by courts to elevate the constitutionality of laws, especially those affecting fundamental rights, such as the right to bear arms. Under this scrutiny, the government must prove that the law is narrowly tailored to achieve a compelling state interest. In the context of the Second Amendment, this means any regulation must closely align with the vital public safety objective without unnecessarily infringing on the rights to bear arms. Now, for the public safety aspect of it, while strict scrutiny protects the right to bear arms, it doesn't prevent the government from enacting regulations to ensure public safety. For instance, the government can implement restrictions to prevent firearm possession by individuals with a history of violent felonies or domestic abuse. These measures are justified as they address a compelling interest, public safety, and are narrowly tailored, targeting specific high-risk groups rather than imposing broad restrictions on all citizens. This approach ensures the protection of constitutional rights while addressing legitimate concerns of safety and crime prevention. With that, Mr. Chairman, I will stand for questions.
Questions, committee. Representative Ruiz.
Thank you, Mr. Chairman. And Representative Carpenter, the words you wrote, or the words you read were very nice. Did you write those?
I did have some help, but yes, I tweaked them and made it my own.
My compliments to you.
Thank you.
Do you think, is there any time a person would lose the right? When we've had several instances brought up about domestic abuse and different situations where a person could forfeit their arms for a while and then get them back. Is there any situation where a person, other than being imprisoned, can lose the right to bear arms or hold firearms?
Well, my understanding is we actually currently have that in place. So if someone's on probation, they're not necessarily in prison, but they're still prohibited from owning or possessing firearms at that point in time. Just like with their right to vote. So we have the ability to take away somebody's right to vote. That is a fundamental right. I think we would all agree on that. But if they're in prison or if they're on probation in the state of Kansas, they no longer have the ability to exercise that right to vote until they have served their sentence. And so once they're off probation, that right is then reestablished to that individual under voting rights. Now, firearms might be a completely different story depending on the severity of that individual with domestic abuse, that type of stuff.
Mr. Chairman, if I may, what level of felony disqualifies you from voting or owning a firearm, possessing a firearm?
I would have to get with the revisor on that. And
Mike, do you have that?
I believe it's any felony, actually. I'll send out an email to the committee, but I think it's any felony.
Thank you. Thank you, Mr. Chairman.
Very good. Representative Hauser.
Thank you, Mr. Chair. Thanks for being here, Mr. Speaker Pro Tem. Got a couple questions for you. Can you guys hear me all right? You know as well as I do that I'm pro Second Amendment kind of guy. And how will this constitutional amendment, remember last year what came around we were working on? Let's say I own several of those pistol braces and the BATF was coming after pistol braces. How would this protect me from that?
thank you for the question, Representative, Mr. Chair. I think that the Attorney General, being an attorney, he answered it far better than I probably could. But I'll point to his testimony, what his statements were, in the sense that if Congress passes a law on it, then at that point it supersedes what we have. But then if it's just a regulatory scheme that's put on by the federal agency, then I think at that point in time, there would be the ability to have that debate in court.
Okay, follow-up question on that. So we're still leaving it at, so our Second Amendment right is now in the hands of the court with the strict scrutiny thing, instead of just saying shall not be infringed. So, I sat in this room back in here in 2013, and we passed the Second Amendment Protection Act out of here. As a matter of fact, I had an amendment or two on that I had part of that. And we all know what happened to that. When the time came for a test, everybody went bye-bye, and there was no protection at all. So how would this bill be enforced? Let's say that BATF does manage to get their pistol brace rule through the court system. How would this bill or this constitutional amendment enforce that if they were going to come in? Well, I get that now. They trump us, but that's just it. We don't have any way of any kind of recourse at all, or we're just at the hands of the court system at that time. Is that what I'm getting?
So, Representative, I think you and I have had conversations regarding other constitutional provisions like the 10th Amendment and other discussions and where states' rights begin and end. I think your question is basically getting to that crux of that issue. At this point in time, our government is set up in a way, and I think we have very similar ideals on, to quote Reagan in 1981 for his first State of the Union address, the states created the federal government. The federal government did not create the states. And that being the case, though, under current law and under how the current rulings and everything else and how court decisions have put us in the last 100 years, we are now at a point where we do have to play with the federal government in the sense of when they pass these laws or these types of things, until those court cases start getting overturned or changes in, I believe it's called the jurisprudence. Again, not an attorney, but as soon as those court cases start being revisited by the courts and changing it to where states' rights start becoming more prevalent, then at that point we might see a difference or a change in what the SAPA, the Second Amendment Protection Act, and the end result of that issue. But as of right now, where we currently stand as a country, the federal government again, what the Attorney General said, has the ability to put these laws on us through Congress. Now, that being said, though, the U.S. Constitution is the supreme law of the land. So it doesn't matter if our Constitution says something. If it's counter, if it says, we no longer support the Third Amendment, the ability to, if, no soldiers shall, be housed in homes. Well, we want soldiers housed in homes. Well, we wouldn't be able to say that or do that, even if we put it in our own Constitution, because the U.S. Constitution will still supersede that of our own.
Thank you, Mr. Chair. That's all I have for the moment.
Very good. Thank you very much.
Thank you, Mr. Chairman. Thank you,
Tim.
Committee.